The Bombay High Court has ruled that owners of bigger apartments in residential condominiums governed by the Maharashtra Apartment Ownership Act of 1970 must pay higher maintenance charges compared to owners of smaller flats. Yes, this landmark decision clarified that maintenance fees should be charged in proportion to the size of each apartment, reflecting the undivided share each owner holds in the common areas of the property. This ruling arose from a legal dispute in Treasure Park, a large residential complex in Pune comprising 11 towers and 356 apartments. The managing committee of the society had been collecting equal maintenance charges from all flat owners, regardless of the size of the units. However, owners of smaller flats challenged this practice, arguing that it violated the provisions of the Maharashtra Apartment Ownership Act, which mandates that maintenance charges be levied according to each owner's undivided share in the common property. This share is directly linked to the size of the apartment. The Deputy Registrar of Cooperative Societies supported the smaller flat owners and ordered the society to collect maintenance fees proportionately based on apartment size. Larger flat owners then appealed to the Cooperative Court in Pune, which dismissed their case. Subsequently, they approached the Bombay High Court. The larger flat owners contended that common facilities and amenities are used equally by all residents, so maintenance charges should be uniform. They argued that charging higher fees to bigger flats was unfair, as it assumed more residents and usage without basis. However, the High Court disagreed with this reasoning. Justice Milind Jadhav emphasized that the law and the condominium's own declaration documents clearly support a system of proportionate maintenance charges. He explained that owners of larger flats hold a correspondingly larger undivided interest in the common areas and therefore must contribute more to their upkeep. The court dismissed the petition filed by the larger flat owners, affirming that maintenance charges must be based on the size of the apartment and the undivided share in the property. This ruling distinguishes apartment condominiums governed by the 1970 Act from cooperative housing societies governed by the Maharashtra Cooperative Societies Act of 1960 or the 1971 Act. In cooperative societies, maintenance charges are typically equal per flat because members own shares in the society rather than undivided interest in the property. In contrast, under the 1970 Act, apartment owners have legal ownership of an undivided share in the land and common areas, making them co-owners of the entire premises. This legal framework justifies charging maintenance fees proportionate to the size of each flat. The court also noted that the petitioners, who are the owners of larger flats, had benefited for years under the equal maintenance charge system and could not now obstruct the implementation of statutory provisions. The judgment reinforces that the registered deed of declaration of the condominium, which defines ownership shares and maintenance obligations, cannot be disregarded. This decision does have significant implications for apartment owners and managing committees across Maharashtra and potentially other states where the 1970 Act applies. It provides legal clarity that maintenance charges must reflect the ownership structure and size of flats, ensuring fairness and compliance with the law. Managing committees will need to revise their maintenance billing systems to align with this ruling, charging owners of bigger apartments higher fees to cover their proportionate share of common area expenses. For more news and updates, keep watching Live Mint.